Good afternoon, everyone, and สวัสดีค่ะ My name is Pibimon Vipamani Rat Orjun. I am a partner and head of our firm's non-contentious employment group at Telekian Gibbons, Bangkok office. Today, I'm here with our regional team to give a presentation on termination of employment due to poor performance. First of all, I would like to introduce the members of our regional employment team who will give presentation today. First, Sarah Karasi. Sarah is our senior counsel who has been practicing employment law in Vietnam for over 9 years. Second, Dino Santaniello. Dino will join the session for Laos. Dino is the head of Telekian Gibbons office in Laos, where he has been based permanently for about 7 years. He has regularly advised on employment matters since he has joined Telekian Gibbons. Next, Nitika Nis. Nitika is an associate in our Cambodia office. She has extensive experience in employment practice. She provides regulatory advice under Cambodian laws, and she has assisted various clients in labor dispute resolution proceedings since 2018. And last but not least, Kun Yuvadi Thengam. Kun Yuvadi is a partner and director of Telekian Gibbons Myanmar practice, having moved to oversee the firm's Yangon office in 2013. She oversees a wide variety of matters, including labor laws and employment regulations in Myanmar. Our presentations will comprise 2 parts. In the first part, we will discuss the employer's obligations when terminating its employees due to poor performance. For the second part, we will discuss the consequences for termination and potential claim for unfair termination. I am now pleased to invite Sarah to give us an overview of Vietnamese law with respect to the employer's obligations when terminating its employees due to poor performance. Sarah, the floor is for you.
Okay, thank you very much, Kunjun. So thank you for joining us today. Just wait. Okay, so as Kunjun mentioned, first we'll discuss employers' obligations. Poor performance terminations are very complicated in Vietnam. They're very difficult. However, the Labor Code does provide a legal basis. An employer may terminate an employee if the employee repeatedly fails to perform his or her work according to the criteria for assessment of employment duties established by the employer. So what this means is that in advance of the employee's poor performance, the employer must have a performance management policy in place that sets out the criteria for assessment of fulfillment of the employee's duties. If a corporate level trade union exists, this policy must be consulted upon with them, or if an employee representative organization, this would be an independent trade union. And it's outlined under the new Labor Code. However, we're still waiting for a decree for these types of organizations to actually be formed and registered. But in any case, so if there's an employee representative organization within the enterprise, they must be consulted on the policy. Employees also need to have clear job descriptions in their labor contracts so that the assigned tasks are clear. In addition to the foregoing, the new Labor Code sets out an additional requirement. So the performance management policy must not only be consulted upon with the trade union, it must also be subject to a dialogue in the workplace session. These sessions basically are quite onerous to undertake. Prior to conducting the dialogue in the workplace session, the employees should receive notice of at least 5 working days. Then the employee representative groups need to canvass their members and collect opinions, and then present these opinions to the other representative groups. And just to give you a bit of background, employers are supposed to basically organize their employees to have a representative for unionized employees and also for non-unionized employees. So these would be treated as different groups and have their own representatives. The employer would also have its own representatives of at least 3 people, including the official legal representative. So after this process, then the dialogue session would take place. The different representatives of these groups would present their group's opinions on the performance management policy, and written minutes would be taken. And these minutes would have to be publicized to all employees within 3 working days. The law requires that an employee repeatedly fails to complete his or her assigned tasks. So this means that before terminating an individual for poor performance, the individual has to be subject to a performance improvement policy or performance improvement plan. The PIP would set out specific objectives for the employee to complete within a certain time frame, and this is normally about 3 months long. After that 3-month period, another PIP is completed. If the employee achieves the goals, then he or she is released from the process. If the employee does not meet the goals, the employer may then issue a notice of termination after conducting another dialogue in the workplace session, following that long process that I explained previously. So you can see in Vietnam, it's very complicated. With the PIP, there's not a set form for how long the performance improvement period has to be or exactly how it's conducted, but this is expected by the authorities as a matter of practice, and 3 months is the normal time frame. So once the employer has gone through all these processes, the dialogue in the workplace session about terminating the individual due to poor performance, then the employer must also give the employee notice. If the individual has an indefinite term contract, they are then entitled to 45 calendar days of notice. If it's a definite term contract of 12 to 36 months, it's 30 days. And if they have a definite term contract under 12 months, it's 3 working days. Employees are also entitled to severance, which I'll explain shortly, for working periods not covered by unemployment insurance in the case of a poor performance termination. In order to be entitled to severance, the employee must have worked for at least 12 months before being terminated. It only applies to working periods not covered by unemployment insurance. So unemployment insurance was introduced in Vietnam in 2009. So that would mean very long-standing employees would be entitled. There are also often gaps in the parties' participation in unemployment insurance, especially in the case of maternity leave. So maternity leave is 6 months in Vietnam. So usually you'll find that the female employees will often be entitled to some severance allowance because they didn't contribute to unemployment insurance over that time. And foreign employees are also subject to severance allowance because they don't participate in unemployment insurance. Severance is equal to half a month's salary per year of service. And periods of under 6 months are rounded up to half a year, while periods over 6 months are rounded to a full year. And the employee's salary or their average salary over the 6-month period immediately preceding their termination is used to calculate severance. And employees must be paid all termination entitlements within at least 14 working days of their termination. So in addition to severance, this would also include things like accrued unused annual leave and a pro rata amount of any non-discretionary bonus. Okay, so now my colleague Dino from Laos will explain regulations on poor performance there.
Hi everybody, I'm really happy to be with you today. So I'm Dino, I'm living in Laos and heading the TDK and Gibbons office in Laos for 7 years, as Jun said earlier. And I will be speaking about termination on based on poor performance and their Lao perspective. So without further ado, here is the obligations of the employer whenever an employer wants to terminate a employment agreement due to poor performance. So just a quick note first is that in the Lao law, we do not speak literally of poor performance, but we'll speak of lack of capability or lack of expertise. But all in all, it provides just exactly the same, entitle the employer to terminate an employment agreement based on the fact that the employee wasn't able to meet with the standard of the company or the work quality of the company. So accordingly, I will speak indistinctively of poor performance, lack of capability, or lack of expertise during that presentation. And this issue of semantic does not affect at all the rest of the presentation. So here, as you can see, we have listed most of the obligations, the salient obligations, I would say, of the employer whenever an employee wants to terminate an employment agreement based on poor performance. So the law and labor does speak explicitly of poor performance. So that's a good news. First, sometimes the Lao law is not very clear, but that's not the case here. This is the law and labor article 82 item 1, which will set the two, I would say, primary main conditions in order to terminate an employment agreement based on poor performance. So what the article 82 actually says. The article 82 of the law and labor provides two key conditions. First of all, indeed, the poor performance. However, unlike to Vietnam, there is not much definition about what is a poor performance. So that is something that we have to be evidenced by the employer. The second condition is something that is maybe specific to Laos, is that prior to terminating an employee based on poor performance, the employer will be also required to assign the employee to other duties that fit the skills of the employee. Just for your information, we'll get back to this principle, to this definition a little bit later in the slides. And on the top of that, we also think that there is another key condition that is not provided under the law and labor, but which can be seen in some judgment of justice in Laos, is the issuance of warning notice. So basically, when an employer wants to terminate an employment agreement based on poor performance, the first action would be to first issue a warning notice or notification to the employee, informing the employee of the poor performance and providing the reason. And after that, the employer will trigger the measures to try to ameliorate the performance of the employee by assigning the employee to other duties. Then, and only then, if the employee fails to meet with the standard of the company or the work quality of the company, the employer can provide the actual advance notice of termination. This is because if the employer is entitled to terminate an employee based on poor performance, the employee is also entitled to receive severance payment and to be warned before being terminated. So once we have those three steps, so the issuance of a warning notice, the assignment of the employee to other duties, the provision of the advance notice, which may differ depending on the category of the employee, but we will see that in the next slide. Then the employee will have also the obligations to pay statutory severance payment, on which we will see there is a specific rate for that. Everything that is due to the employee, so overtime, unused annual leave also as well, holiday overtime indeed, and also all of the payment that may be provided in the employment agreement and all of the benefits that the employee have enjoyed through the employment agreement or other type of side agreements between the employer and the employee. This could be for Laos, for instance, under the internal regulation of the company, which may provide specific benefit to employees. And the last stage is actually the issuance of a reference certificate as provided under the law and labor, which has to be provided 7 days after the last day of work of the employee. So this reference certificate is just, there is no specific template actually, and this is a certificate that must include, so the letterhead of the company, Also, the name of the employee, the time period the employee worked in the company, and then at what position. No comment is necessary from the employer here unless it's a positive comment, because the objective is not to prevent the employee from obtaining or getting a new job indeed. So just a quick focus on the advance notice for termination. So in Laos, roughly, we could say there are two types of employees. First, the employee using manual workforce. So I just give a very quick example about employees working in the garment factory, for instance, but it could be in the construction site also as well, without, I would say, no high level of education. So for those employees, the advance notice period would be of 30 days. While on the other hand, we have also another category of employees under the law and labor, which is the employee which has a specific expertise. Here I try to provide some guidance by providing a non-exhaustive list of positions that may be accounted for employment with having a specific expertise. So here, accountant, legal counsel, director, engineer, and the list could go could be way longer than this. So for this type of employee, there is actually an advance notice period of 45 days that must be provided by the employer to the employee prior to the termination. Now, two key elements also as well of terminating an employee. So first of all, the severance payment. We mentioned it earlier. Whenever an employer wants to terminate an employee based on poor performance, the employer will be obligated to grant the employee with severance payment. So the calculation of severance payment in Laos is very easy. It's 10% of the last total wage multiplied by the total month worked in the company. So that could be quite substantive, actually. And another thing also to know is that this severance payment cannot be capped. Even though, for instance, in the employment agreement, the employer would like to cap in order to minimize the risk of any severance payment in the future, this will likely not be accepted if the matter goes before the Lao People's Court, because the law and labor does not provide any flexibility in order to agree with the to have an agreement between the employer and the employee to cap the severance payment. The other maybe conditions that I think are very obligation, very important whenever an employer wants to terminate an employee based on poor performance would be the assigning of the employee to other duties. So what that means exactly. So here is, as I said, the Article 82, Item 1 of the Law and Labor, which provides specifically this requirement and which says the employee is required to assign the employee to other duties that fit its skills prior to terminating the employment agreement. So I will maybe try to raise an example that I may know best, a law firm. So I do manage a law firm. I have several associates working for me under my supervision. And I may notice that one of my associates, which never happened actually, had very poor performance. So what do I do? So first of all, the thing I would do is to provide a notice telling that my associate is subject to poor performance and we would like the associate to perform better. Then we have several departments in a law firm, or we do cover a lot of legal areas. So it could be intellectual property, it could be corporate commercial, it could be employment indeed. So if my associate, for instance, were working for handling litigation matter, and I feel like the associate does not perform very well, I may try the associate to other duties, let's say intellectual property or employment matters, and see if the employee performs well. Only if the employee fails to perform well again, then I may provide the advance notice and trigger the termination procedure. One thing also as well to note is that whenever an employer assigns an employee to other duties that may be less sensitive or have less responsibility, that cannot be an excuse to decrease the salary, because indeed the salary decrease will have to be agreed with the employee. So for this first part, that would be it for Laos. I will pass the floor on to my colleague Nitika for Cambodia.
Thank you, Dino. Hi, I'm Nitika. We'll be speaking of Cambodia. So in Cambodia, it's not too different from Laos and other jurisdictions, but we don't really have a specific definition of poor performance for employees' performance. So however, before I'm going to discuss directly in relation to termination, it would be necessary to define the two different types of employment contract under Cambodian laws, because each respective employment contract would lead to different benefits and proceeding to terminate employee. First of all, we have fixed duration contract, which we can call FDC. So FDC in Cambodia have to be in a maximum of 2 years term, and it's subsequent to renew, but the total duration of the renewal cannot be more than 2 years, meaning that each FDC have to be a maximum duration of 2 years term. So the total maximum of FDC should be less than 4 years. Otherwise, if it's more than 4 years term of the total FDCs, it would be deemed as UDC or undetermined duration contracts. So how to terminate an FDC due to poor performance? At rule, sorry, there might be a delay in my slide when I'm speaking. However, I will try the best to provide you some background. For termination an FDC due to performance at rule under the Cambodian labor law, employer cannot unilaterally terminate an FDC before its due date or its expiration date. I think the slide is not moving. I may need assistance from our colleague. Okay. So at rule, employer may not unilaterally terminate an FDC before its expiration date, meaning that in practice, from Cambodian perspective, the labor law provides employer to hire employees under FDC after probation period. So from Cambodian perspective, employer may use probation period to judge the capability or the performance of employee, whether they would consider to hire their employees in question under an FDC or not. So that's why in practice, if employer surpass the probation period and they may wanted to terminate their employee due to poor performance afterward, it would be challenging that such termination due to poor performance after the probation period would be entitled to an unfair termination. This is very crucial for Cambodian practice, and we may be able to discuss that in further slides for our second part and how to avoid it. However, in case of termination due to poor performance, employer would be obligated to, first of all, provide damages of termination at least equal to the wages and benefit that employee would have received had the contract been fulfilled in full. For example, if the employee has an FDC which 2 years term, and after 1 year term, employer wanted to terminate an FDC because the employee has not performed a good or a fair performance for in accordance with the company's policy. So meaning that for the remaining 1 year term, the employer have to provide all the wages should be paid if the contract have been fulfilled in 2 years full terms. And secondly, they have to pay statutory severance. And in Cambodia, there's the Cambodian law specifically defines the difference between the terms. Severance payment is used for fixed FDC, a fixed duration contract. But seniority, we refer to seniority payment, which I will discuss in the upcoming slide, is only used for an UDC. So severance payment for an FDC have to be 5% of the employee's total paid wages. And employer have to pay all the wages, overtime pay through the last day of employment to the respective employee, and also for any unused annual leave, if any. Also, this is important to highlight that if there are any bonuses or any other additional payments due under the employment agreement and other applicable terms of employment, meaning that under internal policy, internal rule of the company, employer will be bound by those obligations and have to pay all the other additional payments to employee. This is important to know because in practice, the Cambodian labor mediator of the court will refer to all the additional payment which are more generous than the minimum requirement than the labor law to be bound with the employer's obligation. And last but not least, the employer have to issue a certificate of employment. And this is same as Laos of that employer have to provide a fair statement which are not harmful to the employee's reputation in order to find the future job in the or the future employment. So for these obligations, especially for all the payments, this is to note that the employer have to make all the payment within 48 hours after the termination. And next, I would discuss regarding the advance notice. However, as I mentioned earlier, that for an FDC at rule, employer may not terminate an FDC before its expiration date. However, if employer wanted to terminate an FDC, they may wait up until the expiration date of the FDC due date, meaning that they have to provide notice under the employment service. Is an FDC is I cannot move my slide. If an FDC is if the employee has been working for at least 6 months to 1 year, so before its expiration date of 1 year term or 6 month term, employer have to provide a notice of not renew the FDC with employee within 10 days before its expiration date. And also, if employee has been working for 1 or 2 years, 2 years is the maximum duration of an FDC. So for your attention, that FDC cannot be more than 2 years term. So if it's from 1 to 2 years term, employer have to provide 15 days before its expiration in order to provide the decision that they will not renew an FDC with their respective employee. So that's it for FDC. Now we are moving to UDC. UDC is more simple because UDC is we can call it like unfixed duration contract or indefinite contract. So in Cambodian, when employer enters to an FDC with their employee, they may have a certain obligation required under the law, which I want to highlight specifically for Cambodia. We call it to pay seniority and seniority pay. And this is new. This has been implemented since 2018 and 19, but it was to highlight that for seniority pay, employer for every annual or every year, employer have to pay ongoing salary due in the second payment of salary in June and December. So there are 2 time payment of seniority pay, meaning that employer would be able to terminate their employee due to performance, unlike an FDC. That's why here we don't discuss the damages, because employer would be only obligated to pay wages, salary through the last day of employment and provide advance notice of termination or make payment in the days of, meaning that if they don't comply with the duration of advance notice, they will have to make payment. And also for any unused annual leave, they have to make payment to employee. And seniority payment, as I mentioned, if the employee has been working at least from 1 month to 6 months in each semester, we start counting from January to June, because in June, in the second payment, salary payment, the employer have to provide a 7.5 days of seniority pay to employee. And so meaning that if employer terminates their employee in June, they have to provide a statutory seniority pay of 7 days only in case of termination. But if it's not termination as unusual obligation, they have to provide 7.5 days. However, we speak of poor performance, termination due to poor performance. So this case, employer had to provide 7 days of seniority pay in June. And then there's another second semester that I mentioned, starting from June to December. So from June to December, every employee under UDC will be entitled to 7.5 days of their wages, meaning that seniority pay for the second semester of the year. So if the employer terminates the employee in July or August, such employee will be also entitled to 7 days of seniority pay. We can discuss that in later detail if you have any question, because we cannot go in detail due to the time constraint. And then if there are the back pay seniority indemnity before 2019 has not been paid yet, the employer have to pay a total package of the back pay seniority indemnity. As I mentioned that in Cambodia, we have 2, the back pay seniority and the ongoing seniority. Ongoing refer to the seniority after 2019. And if the employee has been working since 2015 or 18, such employee will be entitled to back pay seniority indemnity. However, due to time constraint, we could not provide you a full image of the seniority indemnity payment. And last, employer have to provide a employment certificate, which is the same. They could not provide any harmful statement to their employees. And as for advance notice or previous notice, this is entitled to, it's the next slide, but it's going to come soon. As for advance notice, it's subject to the length of service of employee, meaning that if the this is contrast. So if the this is an error between these 2 tables. This should be advance notice of termination, and this should be length of continuous service. Sorry for that inconvenience. However, if the employee has been working for at least 6 months, the employer have to provide 7 days of notice, and respectively until more than 10 years, they have to provide at least 3 months of prior notice. That's all from Cambodian. I will hand over to our colleague, Kon Yuvati, who will speak for Myanmar's perspective. Thank you for your attention. Hand over to Kon Yuvati.
Thank you very much, Nitika. and good afternoon, everyone. Okay, I will speak for Myanmar about the poor performance based on the current situation. As everyone know about the situation in Myanmar, there may occur some situation of the poor performance of the employees. However, we can consider based on my presentations and also consider about the current situation together. In Myanmar, as you may know about, if under the Employment and Skill Development Law that issued in 2013 that announced about employer and employees need to have the employment contract. But the officially first draft of the employment contract was issued in 2016 for the employer who have the employee more than 5 persons can start to register with the respective township labor office for the employment contract. In that template also mentioned about how to terminate the employees and also the conditions for the terminations. As the Vietnam and Laos, in Myanmar there have no definitions or the official definition on the poor performance. However, we can consider under non-gross misconduct. This is the under the regulation that issued by Ministry of Labor in Myanmar. The issue for 2 matters about gross of misconduct. It's about serious offense or criminal matters and also non-gross misconduct. If we consider about the poor performance, as you may see my highlight in orange in these tables, it may related to about non-carry out duties and directive that rendered by the head of department or the company policy or any not perform the duties and complete the tasks as per job descriptions that already mentioned when you apply for the company, as you may follow about the description that you already discussed with the employer when you start working with the companies. Another one is about the performance to be sufficient at meet KPI, because some company, for example, the trading company or some sale company that need to require to add the KPI for the sale person or the sale manager. That one, if it's not meet these requirements, it may cause on the termination or about poor performance based on these matters. In regard to the dismissal, this one also mentioned in the employment contract templates that issued by the Ministry of Labor, and also they have some update in 2017. It also mentions about this. If they have some warning written for the matter that under the non-gross misconduct, you need to send the 3-time notice. For example, first one is about verbal warnings for any offense or any matters that not meet the requirement. The second one should be issued by the letters. And the last one is about sign acknowledgement for the wrongdoings. However, these 3 steps need to be happen in the same period within 12 months. However, in case of the company who have planned or which have planned to close down of the company, or that employee very poor performance and any others with reasons, you can make the 1-month notice of the terminations to the employee who non-perform or not meet the requirements under the company policy. This one also may need to be considered based on the sovereign pay and other benefit that company need to pay. However, for the bonus, it's not mandatory required under the current regulation in Myanmar. However, if any employers or any company always pays the bonus, you may need to consider to pay the bonus add up on the sovereign pay. And also the same with Laos and Cambodia. If they have unleave or non-leave remain, you also can consider to pay for them as well. However, in case of gross misconduct, for example, some criminal offense, this one the employer can terminate without any payment of the sovereign pay. This is the table of the sovereign payment that issued by Ministry of Labor under the notification 84 since 2015. You can see if the duration of the work period is less than 6 months, that person will not get any sovereign pay. However, from 6 months to 25 years, the employee may subject to pay based on the long period of the workings based on this table from 0.5 months to 13 months is the maximum under the Myanmar sovereign payment regulations in Myanmar. This is for my summary about the termination employment scenario in case of the poor performance. Mostly, as I mentioned, the poor performance may need to be required 1 month notice, as you can see. Yes, I can see the you can see in the table number 2. The sovereign payment need to pay, yes, and also need to be provide the reasons and record for the reason. Yes, for example, the reason of the poor performance not meet the KPI, not provide and meet at the job description. This one you can mention in the reasons for the termination. In case if your company have the employee more than 30 employee, you can set up the workplace coordination committee to be from the 3 persons from the employer side and 3 persons from the employee side to consider in any dispute internal in your companies or the employers consideration and regulations to make the decision on the illegal or unfair termination to the employees. Okay, I will pass to Kunjun Pivimon about the regulation in Thailand.
Thanks, Kun Yudi. Now I will talk about the termination due to poor performance under Thai law. Under Thai law, the termination due to poor performance is regarded as termination without cause. When an employer terminates an employee without cause, the employer is obligated to give the employees first to give the advance notice of termination or make payment in lieu thereof. I will talk about the advance notice in detail because Thailand advance notice is quite specific, unlike other jurisdictions. Second one is pay severance pay that I will talk in detail later as well. The third one have to pay wages, overtime pays, holiday pays, and holiday overtime pays throughout the last day of employment. Fourth, to pay make payment in lieu of any unused annual leave. Okay, and 5, return security deposit if any, because you may know that in some position the employer may request the employees to provide the security deposit. So upon termination of employment, the employer will be required to return the security deposit to the employees. And 6 is to pay any other payment due upon the termination under the applicable employment agreement and any term of employment. And 7, to issue the certificate of employment. Similar to other jurisdictions, that the certificate of employment, you just make it very simple. Just say that the name of the employees, the commencement date, and the end date. And you can say about the position of employee as well. Just make it in short. Now, I will discuss about the advance notice of termination. As I told you, Thai labor law is very specific on the advance notice of termination. The employer may terminate the employment agreement by giving advance notice of termination on or before any date of that payment In order for the termination to take effect as of the following date of the wage payment, this is known as one pay period notice. In other words, there must be one complete payment cycle between the date the employee is notified of his or her termination and the date the termination takes effect. The required notice of termination is often misunderstood. Employers who pay their employees monthly often think that they must simply give 30 days advance notice or 1 month's notice. However, as I have just explained, the required notice of termination under Thai law is one pay period notice, which can be longer than 30 days, depending on the employee's payday and the date the notice of termination is actually given. Therefore, when an employer wishes to terminate an employee without cause due to poor performance, the employer must take the date of payments of wages into consideration. For example, if an employee receives wages once a month on the 25th of each month, and the employer wishes to terminate the employee effective on the 25th of March, or at the end of March, the employer must provide advance notice of termination to the employee on or before 25th of February. If the employer gives a notice of termination after 25th of February, say 26th of February, then the effective date of termination will push later to at least on the 25th of April. In any event, the employer may choose to deliver a notice of termination with immediate effect, provided that payment in lieu of notice is made to the employee. Therefore, employers should carefully time when they give the advance notice of termination to the employees. Otherwise, the employer may end up paying higher or more wages in lieu of notice. However, if a longer notice period was agreed upon in the employment agreement or in the employer's work rules, the employer is obligated to comply with such agreed notice period. Now I will talk about severance pay. Okay. Severance pay in Thailand range from 30 days to 400 days, depending on the length of the employee's service with the employer. You can see that if the employees completed 120 days, but less than 1 year, severance pay is 30 days. Completed 1 year of service, but less than 3 years is 90 days. Completed 3 years, but less than 6 years is 180 days. 6 years, but less than 10 years is 240 days. Completed 10 years, but less than 20 years is 300 days. And completed 20 years or more is 400 days, which is the maximum severance pay under Thai law. Severance pay is calculated on the basis of the employee's last wage rate with the employers. Therefore, in addition to the basic monthly wage, if the employee also receives or is entitled to receive allowance or other employment benefit, it is important to determine whether such allowances or benefits would be regarded as part of the wages in calculating the employee's severance pay, notice pay, or any other payments which use wages as the basis for calculation. For example, the payment for unused annual leave. As a general rule, any money that the employee receive or allowances given by periodic payment for which the employee does not need to submit receipts for reimbursements and which is paid in respect to the employee's normal work would constitute part of employees' wages. On the other hand, in general, money which is paid as welfare and which is not paid in respect to the employee's normal work and or reimbursement for expenses incurred would not be regarded as part of the employee's wages. For example, if an employer agreed to provide its employee with certain benefits in a form of money in a fixed amount and paid on a regular basis, for example, a position allowance of 10,000 baht a month, a housing allowance of 50,000 baht a month, transportation allowance of 20,000 baht a month, and without requiring the employees to provide receipts or any other supporting documents or evidence to reimburse such payment, the Thai court will likely determine such monthly allowances are part of wages for the purpose of calculating severance. Other benefits which are not in the form of money, for example, a car with a driver, health insurance, are not regarded as wages. Whether the Thai court decides that specific allowances should be excluded or included as part of the wages for the calculation of severance and all other payments. This would depend on how such allowances are paid to the employees and the term and conditions of employment made and enter between the employers and the employees. Okay, that is for now for Thailand. Now I would like to provide you with a summary for advance notice of termination and severance pay for each jurisdictions. You can see that each jurisdiction will have different obligations for employer when terminating its employees due to poor performance as shown in the table. We can give you the slide presentation if you would like to, so you can see the differences from each jurisdiction here. So now let's move on to the second part of our presentation. We will now discuss the consequences for termination and potential claims for unfair termination. Sarah, please tell us about this issue under Vietnamese law.
Okay, thank you, Kunjun. Sure. So in Vietnamese law, having an unlawful termination claim arising from a poor performance termination is actually very common and a very big risk. Because as I outlined in part 1, it's a very complicated procedure in Vietnam. One thing about Vietnam is that dialogue in the workplace requirement is fairly new. That just came in with the new labor code that went into effect in 2021. So a lot of employers don't really know how to implement it or aren't aware of it. And so there is a very big risk of facing an unlawful termination claim. If basically if any procedural step is missed in Vietnam, so for example, if the dialogue in the workplace session were skipped, if the employee didn't have a chance to improve their performance, they can make a claim for unlawful termination and they would likely win. If the employee brought a lawsuit and won a claim, the court would order mandatory reinstatement of the employee. A lot of people are very shocked at this remedy in Vietnam. In most other jurisdictions, it's an optional remedy, which may apply in some cases, but not all. But in Vietnam, it applies in all cases. And this can be especially problematic if you have an employee on an indefinite term contract, because then that employee is back basically until they reach retirement age or until they have until the employer has another legal basis to lawfully terminate them. It's something employers should keep in mind, that they should have employees on fixed term contracts for basically as long as they can. For Vietnamese employers can have a maximum of 2 fixed term contracts before they're forced to put the employee on a permanent contract. And there's no minimum term for the fixed term contract, but there's a maximum term of 36 months. So employers, I normally recommend my clients, if you're hiring someone new, put them on maybe a 1-year contract to begin with. And then if they perform well, then put them on a 3-year contract, basically to deal with the challenges with this. But anyways, so if they win a wrongful termination lawsuit, the employee is reinstated and they receive back pay for the period during which they could not work. And this would also include statutory insurance contributions. And there's a 12-month limitation period in Vietnam. So what employees will often do is if they're unlawfully terminated, they often wait until that limitation period is almost over and then they bring their lawsuit because they would get the back pay for that period as well. There's also an additional compensation payment of at least 2 months for emotional distress. So this amount could actually even be higher. If the employee decides not to come back to work, the above would apply, plus an additional 2 months salary and severance allowance. But keep in mind, the employee has to agree not to come back. So what happens in practice is the employee will demand a really exorbitant amount not to come back. So they basically would have all the bargaining power in that situation. So just in sum, I really recommend to carefully look at all the legal procedures if you are considering making a poor performance termination, and especially if your company lacks the necessary policies that should be in place before you go ahead with all this. So keep in mind, at the time the employee performs poorly, they need to have a clear job description setting out their duties. And you also need to have that performance management policy in place. And if you're putting that in place after 2021, it needs to be subject to that dialogue in the workplace session, as well as trade union consultation in order to be effective. So those are my main takeaways from that point. If your company is lacking that, then I would recommend to negotiate mutual termination. And even if you do have the proper policies, as you can see, there's so many procedures involved and a lot of time. So realistically, if you want to terminate someone for poor performance, it will take you several months. So really, in any case, it's best to first try to negotiate mutual termination. And then if your company has the legal basis and the employee refuses mutual termination, then you can proceed with all the policies and procedures. Okay, so now I'll turn the floor over to my colleague Dino from Laos.
So for Laos, so what are the consequences for if the employer meets the obligations to terminate correctly a employment agreement based on the poor performance? So most likely the termination will be considered as a unfair termination, or maybe more particularly in the Lao labor law, unjustified termination without sufficient reason accordingly. And so the concrete consequences would be, so first of all, it is possible that the employee claim the reinstatement in the company. The employee is totally, can totally ask so. But in practice, this is not what we have actually witnessed. Most of the time, there is a breach of trust, which would prevent the employee to actually request going back to the company and keep working with the same employer. So most likely what will happen is that the employee will take the compensation, and we will see accrued civil payment also as well, and just try to find a job somewhere else. Can the court actually request all the reinstatement? I mean, why not? But if the employee is not requesting it, it's most likely that the court will just do as the employee wants to do, meaning that the employee will just take the compensation payment, accrued civil payment also as well, and try to find a job somewhere else. Now, what could happen also as well is that because of the consequences of unfair termination is that the employee may be entitled to payment of damages, in addition to all the statutory payment that we've seen in the first slides relating to Laos in the first part. So here, what could that be? For me, what come to my mind would be For instance, maybe that's specific to fixed term contract. Let's say there is a fixed term employment agreement of 10 months. After 3 months, there is a termination based on poor performance, but this is an unfair and justified termination. So here the employee actually may be entitled to request the severance payment and all the payment that it must be paid by the employer to the employee. But in addition to that, what the employee may be entitled to, it would be the payment of the remainder of the salaries. So if after 2 months of employment in a fixed term contract, there is unfair termination, let's say here that the employee would be entitled to request for the payment of the 8 more months that were supposed to be paid under the fixed term employment agreement. So that one thing. And one of the key, I would say, consequence also as well would be the severance payment that would be accrued to 15%. As you may recall in the first slide relating to Laos, we talked about severance payment, and then we also provided further details that the severance payment is 10% of the last wage multiplied by the number of month worked, sorry. So in case of unjustified termination, it would be 15% of the last wage multiplied by the number of months worked. One last point, prescription relating to labor dispute. So it's 3 years. I would say that there is no specific prescription or limitation regarding to labor dispute specifically or labor issues. So this is governed under the regime of the common rules of the civil code. There is a lot of debate because the civil code is not very clear as to when start the prescription, but it's commonly accepted by decision of justice, some judgment, or by the labor administration in Laos that here it would start from the day where the unfair or unjustified termination occurred. So that would be 3 years from that day. After this time, then the prescription is over, and it's unlikely that the court will just dismiss the case because of a prescription for prescription reason. So actually, that's about it for Laos. I would pass the floor to my colleague again, Nitika. Nitika, over to you.
Thank you, Dino. As for Cambodian practice, so for Cambodian practice, it's not too different from other jurisdictions regarding the termination. However, I wanted to take your attention again regarding the specific type of employment contract, because it's very crucial to understand the type of your employment contract. If it's an FDC, a fixed duration contract, employer may not be able to terminate it before its expiration date, because I'm speaking of my practical experiences in assisting various clients in labor dispute. However, the labor mediator and the court, they would interpret the termination of an FDC due to poor performance of such employee would be deemed as an unfair termination, unless we could discuss later in detail regarding the documentation and how we could refer to specific type of evidence to prove the legal ground. Because for poor performance for termination of an FDC due to poor performance may be deemed as we call it in Cambodia as a termination without a valid reason. So there's many grounds to define what is a valid reason. However, aside from misconduct by an employee, it will be a very open discussion, and we could that's why, due to time constraint, I may not go to detail how to terminate an FDC with legal ground or valid reason. Nevertheless, we will discuss that what happens if you terminate your employee under FDC, and it would be deemed as an unfair termination. So for an unfair termination, we are entitled employees to receive all the require damages under the law. So in addition to all the payments in year of notice, statutory severance or seniority pay, or unused annual leave, you will have to pay damages. And speaking of reinstatement for employee, the labor law doesn't require employer to reinstate employee who has been terminated, who has been unfairly terminated, unless the employee requested to do so to reinstate into their company, or the court views that such reinstatement or the employment relationship between employer and employee is restorable or repairable. However, it is very unlikely that the court or the labor mediator may suggest, recommend, or order an employer to reinstate employee in case of unfair termination. So as for damages, again, this is the standard damages for specific type of employment contract. For an FTC, in addition to all the required payment, including severance pay, payment of wages, and other unused annual leave, or any bonus or benefit under respective employment contract, employer has to pay employee at least equal to the wages that employee would have received had the contract been fulfilled in full. So again, this is why it is very critical and crucial to terminate an FTC before its expiration date, because the employer may have to pay it double, like the FTC would have never been terminated before its due date. As for UDC, the damages have to be at least equal to the seniority indemnity, and the employee is entitled to, but shall not exceed the wages and benefits of 6 months. So this is upon the wages and benefits that employee is entitled to, and we have to multiply it by, as I mentioned, if such employee has been working for at least 1 month per each semester, or we call it seniority year, such employee will be entitled to 7 days of seniority. And all the payments of damages, all the statutory payment have to be made within 48 hours further to termination. However, the statute of limitation for unfair termination claim for employee is up to 3 years from the effective date of termination. So please do not confuse between the day that you, the date or the time that you have, that employer have to make such statutory payment that we discussed, and the statute of limitation, because statute of limitation refer to the fact that employee can dispose or take any claim to the court for such unfair termination and insufficient payment from their former employer. So that's it for Cambodia. I will give the floor to our colleague Kun Yuvadi for Myanmar. Thank you.
For the unfair termination in Myanmar may different from the other country because there are 5 steps for the employee who would like to claim or file the labor dispute under the Settlement of Labor Dispute Law that updates as of 2019. They provide the options and provide the opportunities for the employee who was terminated by unfair terminations. For the first step, in case of the company who have the employee more than 30 employees, they need to set up the workplace coordination committee in their office or in the company, with including the size of the employer 3% and size of the employee 3% for considerations about the unfair termination reasons and also some compensation that may sufficient or satisfy to the employee or not. In case if the employee is still not satisfied about the decision of the Work Coordinating Committee or WCC, they can file the complaint or file the issue to the level of the township that we call Labor Dispute Settlement Conciliation Body, LDSCB, to intervene for about the whether the decision of WCC is certified or not, or other, is this follow the agreement or is this follow the rule regulation under the labels. If in case unsatisfied by any parties for the employers or employee, they can file complaint to upper levels that we call Labor Dispute Settlement Arbitration Bodies that we call about regions or state levels. This is the one, for example, Yangon regions, Mandalay regions, or Chan state, some kind like that. As the person who work in Myanmar may know about, Myanmar have 7 regions and 7 states. That's why they have an authority by their own region or state. That's why the LDSAB will have the authority to consider about the complaint for each party between the employer and employees. In case each party is still unsatisfied, they have about the level of the national levels that we call Labor Dispute Settlement Arbitration Council, LDSAC. This is the one that deemed to be issue the final between the employer and employee. This arbitration council is combined by the appointment of the laborers who are taking on the employer side, who are taking on the employee side, and who are taking under the government side to consider the issue or the complaint or the claim that raised by LDSAB that I already mentioned about the state and regions levels. In case if still unsatisfied about the decision of LDSAC, actually each party can file the complaint or file the writ to the Union Supreme Court on the decisions of the LASAC. However, under the state of emergency, filing a writ is temporary, is not allowed. That's why if you have any labor dispute, now is may deemed considered as a final state at LDSAC under the current situation of the state of emergency in Myanmar. The consequence of unfair terminations. In Myanmar, normally LDASB under the state of region and regions level or the council levels or the court may order reinstatement to the employee who want to resume to work with the employers at the same company. Will be award for this under the current practice in Myanmar. That's why if the employee make the decision and want to rejoin to that company, the employer must accept this employee to join and continue to work with the company with the continue with the work period and same benefits. And also the court or the arbitration bodies and arbitration councils may ask the employer to pay the damage on any requirement, for example, any compensation wage that during the periods of the consideration by any levels and during the work time period that the employee unable to join and working with the company. And the last one, in case the employee may not want to rejoin or don't want to resume to work with the employers. The employer must pay the severance pay to the employees based on the periods of working time. That may be get from 0.5 to 13 months of the salary that need to pay for the employee. The same as Laos and Cambodia, the statute of the limitations for the employee will be 3 years from the effective of the termination. That's why if in case the employee want to bring the case to the court or want to file some claim to the employer, you need to consider about the periods of limitation. If not, the court may be dismiss your claim or your complaint. Therefore, please consider for these matters. This is all for Myanmar. I will pass to Thailand to Kun Phim Vimol.
Thank you very much, Kun Yuvadi. Now I will discuss the consequences for termination and potential claims for unfair termination. Under Thai law, if the employer terminates the employees without sufficient and justificable reasons and evidence, the employer may be subject to claim for unfair termination, even if the employer makes all payments like payment in lieu of notice, severance pay, and any other payment due upon termination. The terminated employees still have right to bring claims against the employer for unfair termination. And if the court finds that the employee's termination was unfair, the court may order the employers to, the first one, the court may order reinstatement if the employee makes a request to the court, but in practice, the court will likely not to order reinstatements, as the courts know that the relationship between the employers and the employers and employees is not good, and thus they would no longer be in a position to work together. Or the court may order the employer to pay damages for unfair termination in addition to the statutory required payments, like on top of the severance pay, payment of wages in lieu of notice. The calculation of damages for unfair termination is not directly addressed by statute, unlike the severance pay, but has been defined to court practice. The established standard damages is to provide 1 to 2 months for the first year of service and 1 month of wages for the subsequent years of service. Therefore, for example, if an employee has been working for the employer for approximately 2 years, if the employee is unfairly terminated, the court may award the employees 2 to 3 months of wages in addition to the statutory requirement. However, please note that this is only a general guideline. The court is free to award more or less at its discretion. This would depend on various factors, such as the wages of the employees, age of the employees, the working period of the employees, the hardship of the employees at the time of terminations, the reasons for termination, and the compensation which the employee is entitled to receive. In addition, I think it's unlike the prescription period of Laos, Cambodia, and Myanmar. The statute of limitation for unfair termination in Thailand is 10 years from the effective date of termination. So employer, what you have to do is that you have to keep all the evidence that you have if you terminate the employees. So like the reason why you terminate employees, and if you terminate employees due to poor performance, you have to keep the record, the evaluation record of the employees. So perhaps, who knows, the employee may come and bring the claims against the employer in the next 10 years. Okay, that is for Thailand. And Sarah, may I ask you to make a summary for the consequences for termination and potential claims for unfair termination for each jurisdiction?
Okay, so here's a table giving an overview of the compensation and damages available in each jurisdiction. So you'll see that in every jurisdiction, there are damages that would be applicable, except for Myanmar, where only severance would apply. In respect to reinstatement, Vietnam is the only jurisdiction where it's a mandatory remedy. So in all our other regional jurisdictions, the court takes a more reasonable approach and would only apply it in specific circumstances. So I'll just give you a moment to look through that table. All right, so moving on to our Q&A. Now we can open questions up.
Yes, Derek, can you just let us know whether there are any questions? I believe that we still have time for a few questions.
Thank you guys for the presentation. That was very, very useful and comprehensive. We have a few questions here, and I'll try to go through as many as possible. We have about 10 minutes or so to get through them. So for the first one, can you each, maybe in the same order that you presented, advise what is the best approach for an employer to manage termination as a result of poor performance? And as a second part to that, how can employers avoid or mitigate the risk of unfair termination claims? Maybe Sarah, you can start.
Sure. Yeah, so as I was mentioning before, the procedures for poor performance termination in Vietnam are very difficult, and it's a very lengthy process. So you'll see first, the employer would have their initial performance evaluation of the employee and give them an unsatisfactory rating. And then after that, the employer would have to put the person on a performance improvement plan and give them an opportunity to improve. And so the law is not clear on how many opportunities the employee has to have to improve. I've seen more conservative companies give the employees 2 opportunities, but I think 1 opportunity would be sufficient, but that would be about a 3-month period. So if you're looking at that, you have your poor performance evaluation, a 3-month period where the person tries to improve their performance. And then after that, you have to have a dialogue in the workplace session if they've failed the PIP. That typically takes about 2 weeks to organize. And then after that, you can give notice. So you're looking at about 5-month period. So really my recommendation would be, if you do have an employee with poor performance, after that initial performance evaluation where their performance is unsatisfactory, if the company really doesn't have faith in them to improve, it's that is the time to suggest mutual termination. If the employee doesn't agree, then you proceed with the performance improvement plan, and maybe if they fail the PIP, then reopen discussions again and again propose mutual termination. I would only propose to go through all those long procedures if the mutual termination period, if the mutual termination process just doesn't work. In respect to avoiding an unfair or unlawful termination claim, if you are in a position where the person will not agree to a mutual termination agreement, then you have to very carefully follow each procedure because a small procedural flaw can render the whole termination process illegal. So it's very important to carefully follow that. With negotiating a mutual termination agreement, I saw in some of the questions, they were wondering how many months. Typically, negotiations would begin around 2 months' salary, but this will depend basically on the strength of the legal basis of the employer's grounds for termination. So whether they actually have a performance policy in place, whether they have evidence of the poor performance, It would depend on that, and also the type of contract the employee is on. So an employee on an indefinite term contract can be entitled to much more as their ex gratia payment. If someone is on a fixed term contract, the maximum amount would be to pay them out until the end of their contract. Because if they go to court, that's basically what they would get, plus perhaps 2 months salary for plus 2 months salary for emotional distress if you unlawfully terminated them. So yeah, so in sum, if you have a poor performance termination, the best approach is to first suggest the mutual termination agreement. And mutual termination agreements are fairly simple in Vietnam. Basically, both parties have to sign. It's not necessary to register the agreement in the court like Indonesia. The parties just have to sign the agreement. The agreement should reference the provision of the labor code on mutual termination and include a release and waiver in favor of the employer. Okay. So now my colleague Dino can speak about Laos.
Sure. So I would say the best practice for terminating someone based on the poor performance. So the difficulty maybe in Laos is that poor performance is poorly defined, if I may, and so accordingly it's very difficult to be able to prove or to give a correct definition of poor performance by law. So accordingly, I would suggest that the employment contract or any side agreement signed with the employer at the time of the employment of the employee, like an annex to the employment contract, for instance, clearly define the scope of the responsibilities and the scope of work of the employee, whereby would be clearly set out what are the expectations of the employer relating to the employee. Let's say, for instance, if the employee is supposed to speak English very fluently and to be able to attend meetings in English with clients and so on, there should be something that says so, either in an annex of the employment contract or the side agreement, whereby actually the employee would be able to rely on it in order to prove that for instance, the employee was not able to conduct a meeting in English or to answer appropriately in mails in English the employee receives on a daily basis. Things like that. I think so defining the scope of work and responsibility of the employee is very important. Then also providing to the employee annual performance evaluation or even monthly evaluation, whereby the employee will be able to give his opinion about the performance of the employee, which would be another material that could be used in order to evidence the poor performance of the employee. Also, we already stated in the first place, provide a notice or warning to the employee relating to the poor performance, but also maybe emphasize a little bit more on even providing training to the employee, where the employer could say, so we've really tried everything and it still doesn't work. Just to say that, so the employee can avoid as much as possible the unfair termination or unjustified termination. I think that the scope of responsibility of the employee must be clearly defined, which is very difficult. So through the performance evaluation report, the training also as well, in order to avoid that unfortunate situation where we must terminate someone, and the notice will be usually how to say points that we like to emphasize our client to follow before terminating someone based on poor performance. Now, as Vietnam, it's also possible if the employer doesn't want to waste time, maybe in order to trigger the procedure of terminating an employee based on the poor performance, it's totally possible to have a mutual agreement to terminate the employment agreement, which may be faster to negotiate with the employee. But otherwise, I do believe that if you follow the few points that I just provided, it should be enough to justify of the termination based on poor performance, given if there is, of course, a poor performance by the employee here. So that's the tips I would have and insights I would have to give to any employer who would like to ensure that the termination will not be requalified as unjustified termination. Nitika, maybe for Cambodia?
Yes, thank you, Dino. So this for Cambodia, as I mentioned earlier, that the labor law doesn't specifically define the poor performance. So it's very important to note the specific type of the employment contracts, as I keep mentioning again and again. If it's an FDC, as an employer, you should be aware of what would be your obligation, that you may want it to terminate your employee with an FDC, fixed term duration contract, and what are the proceedings you need to follow, because the poor performance itself, the law doesn't specifically define as a valid reason. So it may be risky for you as employer to terminate your employee due to their poor performance. However, it doesn't prohibit employer from terminating their poor performing employee or their poor performing employee if they could have any specific documentations or evidence in place to prove that they conduct a fair proceeding to provide training to their employee, and also they may have the performance evaluation regularly. Here I mentioned that it's very crucial for a fixed term duration contract, because you have a maximum duration of 2 years. So if you wanted to terminate your employee within a 2-year term, you may have your evaluation performance policy in your company for every 6 months or every year, so that you could document all the evidences regarding your employees' performance. And also, it's still it's still challenging that such employee would still claim for such termination before we call it premature termination, meaning that the termination of an FDC before its expiration date is unfair and without a valid reason. And that's being the case, you as employer may have to pay damages, which is not pleasant at all. However, as for UDC, again, it's very open for employer whether they wanted to terminate their employee due to poor performance, unless they can gather all the documentation, evaluation, performance to prove that they could not keep their employment relationship with their employee in question. So overall, the employer shall keep all the documents as evidence which contain the agreement and consent from their employees that such employee doesn't meet the criteria or qualification to pursue their employment service within the company or within the firm. And also, as for in terms of best practice, it's simple. And again, for an FDC, you just provide the notice of termination, because for notice of termination, employer may include all the valid reason and provide at least the specific provision in under a termination letter. We call it termination letter, attached in with the notice, the warning notice, or we call it notice on termination. And then when they provide a notice of termination letter, the employee may consent of their poor performance, and during such period they may have ability to negotiate and to meet or discuss with employer. And that being said, that employer can negotiate and document all the discussion with their employee regarding the termination or their intention to terminate the employee due to their poor performance. And if they could have an agreement. This is the best practice, that employee acknowledge their poor performance, and they could finally consent each other and can have a mature termination agreement. employer may have just to provide an official termination letter and pay all the statutory payment, and finally to issue an employment certificate. This is the best practice. I think that's all for Cambodia. I will hand over to Kun Yuvati for Myanmar. Thanks.
Yeah, thank you very much, Nikita. For Myanmar, actually, we need in the past year we have many factors that you may know about the new and about the current situation in Myanmar. However, based on the current practice, the most important thing is about poor performance, is about job descriptions and the employment contract that you have signed between employer and employee that agree about the condition that employee need to be followed based on the agreements, based on the job description, and based on the company policy, whereas the employee meet that requirement or not. After that, based on the next step is each year, most of companies should have the evaluations period for the employer and employee to have the discussion for the past year about the works of the employee who very good performance or unperform, to inform them. For the employee who unperform, they need to get some warning letters or some warning or freeze of the salary or others that may note to that employee to understand that they have poor performance, to be acknowledged that they used to have this warning before. If not the new situation or new factor that suddenly give them the reason that you are poor performance, something like that, because the poor performance should subject to the performance in the past of the employee. Therefore, after warning, if the employee consider that if the employer consider that employee still unperform or do not have the better performance, they may consider one is about send the warning letters or ask them to terminate or ask them to voluntary resignations or ask them to do the new assignments or ask them to do the training. It depends on the company criteria and about the supervisors who consider about that employee should be fit with each or which criteria that may suit to them. This is the one based on the current practice in Myanmar, and supervisor and employer need to be cooperate with very well to understand about this performance of the employee before terminate. If they collect and record of the reasons for the termination and also the employee understand about their poor performance, this may decrease the unfair termination between employer and employee in Myanmar. And I think it's in the others or general practice of the employment in Myanmar as well. Thank you. I pass to Kun Jun ค่ะ คุณพิมพิมล for the Thai practice.
Thank you, Kun Yuvati. As I mentioned before, that the statute of limitation for the unfair termination claims in Thailand is 10 years, which is very long, 10 years from the effective date of termination. So for Thailand, I would say that in order to mitigate the risks of claim for unfair termination, one approach would be for the employer to meet with the employee to negotiate the employee's voluntary resignation. If agreed, the employee would sign a resignation letter and release document to waive his or her right to claim against the employer for unfair termination. And the employer would agree to make payment of a sum equal to the notice pay, severance pay, and any other amount due under the employment agreement and the employer's work rule or policy to the employees. In practice, employers typically offer additional monetary incentive or a so-called ex gratia payment for the employees to agree to resign and sign release documents. Therefore, please be aware that the employee's resignation is subject to the negotiation between the employer and the employee. As such, the employees may demand more remuneration to resign and to sign the release document. For the ex gratia payment, client often asks us what is the appropriate amount of ex gratia payment. Unlike severance pay, there is no fixed formula for determining the ex gratia payment. As a general matter, I would say that the employer may use the guidelines for damages for unfair termination in order to consider the ex gratia payment. Remember, as I mentioned, for damages for the unfair termination, the court may give for the first year of service, the court may give 1 to 2 months for the first year of service and 1 month for the year of service thereafter. So for example, if an employee has been employed by the employer for 2 years, and if the court finds that the termination was unfair, the court may award damages for unfair termination to the employees in the amount of 2 to 3 months of his or her wages, in addition to the statutory payments. Even if all of these is agreed, the employees who still bring a claim for unfair termination, but the chances of the claim being successful would be reduced by the employees voluntarily resign and by the executed the resignation and release document. However, if the employers and the employees cannot agree on voluntary resignation, the employer could opt to terminate the employee. In this case, it would be essential that the notice of termination clearly outline the reason for termination. For this case, is the performance. So the employer will have to give the reason that why how the employee performed so badly and what's the result. You can have the evaluation result as the evidence, or if you put the employees on PIP, or note that PIP is not the legal requirement under Thai law, but if you would like to terminate employees due to poor performance, you may want to put the employee on the PIP, and the duration of the PIP varies. It can be between 3 months to 6 months. And then you can evaluate the employee during the time of the PIP. And then you can, during the PIP, you may, as Gino mentioned, you may give training and guideline to the employees how to achieve the performance. And if all those have done and the employee performs still bad, you can terminate the employees. But use all the PIP and evaluation result as the evidence. Okay, so it's very important that the notice of termination, the reason is that must be very accurate and supported by strong, solid, and valid evidence in order to protect the employers for claim for unfair terminations. That is for Thailand. How are we doing, Tom, Derek?
Thank you very much, everyone. We're a little bit over time here. We have a lot of questions that we haven't yet gotten to. So I just wanted to ask one last question to all of you. If you could keep your responses quite short so we can end this. And then to all attendees, if your question hasn't been answered, feel free to send the speaker an email with your question and they'll be happy to respond to it. So for the final question, I just want to ask each of you, if an employment agreement stipulates a longer or different notice period than what is required by local law, which period does the company need to follow? The one in the contract or the one under local law? And Sarah, you can start.
Okay. All right. In Vietnam, employees are not allowed to contract out of their rights under the labor code. So the longer notice period in favor of the employer would not be applicable. Meaning, like, if the employee were to resign, the employee could still rely on the notice period under the labor code, which would be 30 days or for a fixed term contract or 45 days for an indefinite term contract. But in a case like this with unilateral termination due to poor performance, if there's a longer notice period and it's beneficial to the employee, then it can apply. So yeah, employers should keep that in mind.
Yeah, for Laos, it's actually there is no response in the law, but I would say the spirit of the law is very beneficial to employees. So if the employee is not against the longer notice period, I mean, why not? But otherwise, if the employee wants to have a shortened advance notice, then probably that this is not the advance notice as stipulated in the employment contract that would prevail, and that would be the advance notice as provided in the law. So 30 days for, like we said, employee having work using manual workforce, or 45 days for employees having some specific skills or having a position requiring a certain high level education.
So for Cambodia, I would like to join with Sarah. Whatever provided under the labor law is very minimal, and what provided is under the labor contract or employment contract, we are more beneficial to employee, that would be applicable. That's it.
The same with Vietnam, Laos, and Cambodia. For Myanmar, which one is more beneficial to the employees? The labor officer may consider for that matters. However, only in the employment contract templates that issued by the government, that only 1 month. However, as I said, some higher level, for example, company directors or any CFO, CEO of company, they may need longer than that. That's one if there is any benefit or to the employee, that's one is will be prefer and favor to the employee for Thailand, for Myanmar, sorry. Pass to Kun Jun ka.
For Thailand, it's very similar to other jurisdictions. You know, as I mentioned before, I mean, if a longer notice period was agreed upon in the employment agreement or the employee work rules, the employer is obligated to comply with such agreed period. Okay, for example, if the agreement saying that either parties may terminate agreement by giving 6 months notice, for instance, you know, the employer will have to comply with the 6-month notice. But for the employee may not require the 6-month notice, and the Thai law will apply only 3 months for the employees maximum. So, but we often see that when the employee resigns, the employee always give a shorter notice. Even you said that in the employment agreement that if the employee want to resign, employee have to give 30 days notice. Some employee may just leave the employment immediately. Then what the employer will have to do? You cannot do anything. You cannot force the employee to continue working for the employer. But what you have to do is that if the employee leave the employment immediately and incur or cause any damages to the employer may bring the claims against the employee for damages. But in practice, no one would do that. So the situation of Thailand is similar to Vietnam, Laos, Cambodia, and Myanmar. So we always look at the benefits of the employees.
Thank you very much, Timbermon and all speakers. With that, I think we can go ahead and close out today's session. So thank you to all of the attendees and to all of our speakers. And again, if you have any remaining questions, feel free to send an email to the relevant speaker by the email address posted on the screen now. I hope you have a good evening. Thank you and goodbye.
Thank you. สวัสดี
Thank you.
ค่ะ
Bye-bye.
Bye.